All right, we're in this book right here today. I'm just gonna show you the book real quick. It's Race Relations in Virginia and Miscegenation in the South. James Hugo Johnston is the author. This is from 1776 to 1860 is what they're talking about, right? Forwarded by Winthrop Jordan. That's what we're gonna get into real quick. Before I do that, let me just pull this out. Okay. It's a disclaimer. There's always a disclaimer. A lot of people are new. A lot of people just, get emotional. They're not understanding. So, like I had a conversation right before I started the video with ChatGPT about what we're about to read, right? All right. Yeah. Thank you, moderators. Yeah. Thank you for just keeping everybody in check, and let people talk. It's all good. If there are questions you can answer, if they're respectful and all that. If they come too much with the hijack, you know what to do already. So this is the first thing I told ChatGPT. This is the first thing I'm going to tell any hijack or anybody doubting or anybody that's new to this. Just want to go ahead and make this clear before we start reading, right? Because we're reading modern interpretations, right? He from the 1900s, right? So it says Negro or slave. This is what I'm telling the ChatGPT, right? Does not automatically mean African origin, birth, or ancestry. Remember, all the research we have done together almost every day, giving examples of what I mean, and the discussions we have had about people being reclassified on paper genocide specifically. I just wanted to start out today with this disclaimer before we get to our topic today. All right, that goes for everybody. But that's what I told ChatGPT. It said, understood. It said terms like Negro, Black, or slave in historical records are not by themselves proof of African origin, ancestry, or birthplace, okay? It's not going to say, no, you're not, no, they all are. See, he is not debating me because it knows real history because I gave it the facts, because it also went to search online. They often function as legal, social, labor, or caste designations, okay? Not about complexion and can reflect reclassification, imposed status, colonial bureaucracy, or later interpretive assumptions rather than clear ethnic origin. Make sure you get that clear before we begin. That is especially important when considering indigenous enslavement, coerced labor systems, racial relabeling, and what you refer to as paper genocide. Yeah, that's what I refer to. That's what it is. And we've discussed the priority is to rely on primary or near contemporary sources. All right, that's what we're going on. Not what you say, not what you think. Get it? Not how you interpret race in modern times. It says distinguish documented origin from later interpretation. That's what we're talking about. What I was just saying. Hey, can somebody please time that person out for 24 hours? Avoid retroactively imposing modern racial categories and accept uncertainty where records do not explicitly state origin. That way they'll know I read the chat. Time them out for 24 hours. Go ahead with today's topic. It says, okay, so I said exactly, we have shown historical sources literally reclassifying American Indians and dark-skinned or Black Europeans as Negroes. So we have to be careful when modern historians infer that Negroes in colonial records automatically means Africans. Look what it said to me right away. I want to show you guys this. Look what it said to me. Correct. It's not debating me. You saw I started the conversation. That's literally how I didn't say, hey, I'm not trying to influence. I asked it, I made statements. I'm making it almost say yes or no, right? Disclaimer, like, right? Before I give you the info, right? Correct. This is exactly why careful source handling matters. Colonial labels like Negro, Black, mulatto, slave, musty, or mestizo, and similar terms were often administrative, okay? And legal categories, not precise ethnographic descriptions. They could reflect labor status, taxation, caste hierarchy, religion, political control, or deliberate reclassification, deliberate, rather than clear ancestry. This is what you need to understand right away. Have as foundation always when you're reading old records. We have discussed documented cases. The ChatGPT, when it's saying we have, because it knows, because it has a memory of all the primary sources. I've shown it when we had discussions about certain topics. I've shown it so many examples of real court cases, American Indians being enslaved, American Indians being reclassified, you know. So it says, when we have discussed documented cases where American Indians were relabeled in records, where indigenous captives entered systems later read as Negro slavery, and where dark-complexioned Europeans or Mediterranean peoples could be described in language that modern readers incorrectly flatten into strictly sub-Saharan African category. Not everybody becomes African. In many colonial systems, officials were concerned with status and control first, not modern biological race categories, okay? That is why a record saying someone was a Negro or a slave in parentheses, right, is not sufficient by itself to prove African origin. Number one point, number one disclaimer when we're reading all this stuff today. Modern interpretations of historians, right? But we're going to interpret the information ourselves because we have a whole foundation behind us, right? We have genealogy, we have primary sources. We know a little bit more than what a lot of these 1900 historians are trying to interpret and say and call people based on primary sources. You know, like, again, the primary sources say Negro or slave, they don't say African. So the stronger standard is to ask, does the primary source explicitly state birthplace, nation, tribe, port of embarkation, kinship network, language, or another direct identifier? Exactly. If not, certainty should be avoided. You can't think you know it. You got it. Oh yeah, he was African. You can't say, oh no, he's European. Oh no, he's white. Oh, he's pale. Oh, he's the, none of that. This is especially important in discussions of early Virginia, Barbados, Spanish, Florida, the Mosquito Coast, Alion's 1526 colony, that's in South Carolina, right, and other Atlantic colonial cases, where later historians often read modern racial assumptions backward into ambiguous records. Okay? So you guys saw how I just said a couple things. I gave it 2 paragraphs. I want you to see that. I gave it 2 little paragraphs. You see how what it just broke down? Correct. Correct, Kurimeo. Correct. All those terms are hijacked, Kurimeo, basically. We're going to prove that today with real court cases and real examples from Virginia. He says, I said, yes, exactly, right? He says, good, we're aligning the standard primary source first, okay. And I said, I'm going to paste chapter 8 of this book, right? So we started talking about something that, I didn't even tell him the subject yet, right? So I'm just now telling it the subject. He's like, all right, go ahead and paste the chapter. I said, yeah. I said, I want to add right here. This is important because we're going to get into this, right? Also, I want to add to keep in mind that white is also ambiguous and does not automatically mean someone with pale skin or even from Europe. All right, pay attention. Many so-called black folks passed for white, and many Indians were labeled white, and many times white was status, right? It was status, not complexion, just like the ambiguity of the word or term Negro. You guys understand? What did it say? Look at the ChatGPT. Agreed. Agreed. And that same caution has to apply to white as well. White in colonial and early American records was often not a simple biological description of pale skin or guaranteed European origin. Wake up, pay attention, take notes, stop being biased, stop generalizing, understand that I'm trying to help you, not trying to act like I know it all and trying to make you seem like you're wrong, or how you thought of history, or how you thought of people, what you thought of a European, or what you thought of a slave, what you thought of a Negro, what you thought of whatever. But it's not about what we think and believe, it's about what the actual sources in history. This is how historical methodological research is done. It could indicate legal standing. White could indicate legal standing, not complexion. Tax status, again, not complexion. Freedom, freedom. not complexion. Land rights, again, not complexion. Militia eligibility, marriage rights, court standings or caste position within the colonial system. Just like Negro, it could function as an administrative category rather than a precise statement of ancestry. We've seen cases where indigenous people were absorbed into white classifications over generations, where people later understood as black, right, in parentheses, passed legally as white, and where complexion alone did not determine the label. In many records, white was a status with legal consequences, not merely a phenotype, okay? A lot of drop going on right now. Hope you guys taking notes. All this is verifiable historical information and truth. That's what the chat is going over because of the stuff I've shown it and because it just literally analyzed what I said and it went to look for it and it knows that's the truth. We've seen cases where indigenous people were absorbed into the white classification. Okay, we got that part, right? So the same rule applies to Negro does not automatically prove African ancestry, right? And white does not automatically prove European ancestry. Pay attention. Slave does not automatically identify ethnicity. That should be an obvious one, but people think slave means African, right? Yeah, mulatto does not always mean a fixed black-white biological category in the modern sense. And we've broken this down, right? Recently, I read the whole history of the word mulatto beginning in the Middle Ages up until 1800s, 1900s. Like we broke it all down, right? If you missed it, check out the videos. The historian's job is to ask what the primary source is actually documenting. That's what a real historian does, not people that say they're historians and just talk. Status, origin, law, caste, kinship, or phenotype, not to import modern assumptions into older terminology. You can't mix what you think of these terms, what these terms mean today with what the people writing in those years, 1600s, 1500s, what they meant when they were using that word. But we've shown so many examples of how wrong that is. And today, even more examples. Again, it just keeps going because this is real history. So, I pasted the chapter. We're gonna get back to that. We're gonna get back to his breakdown. I want to show you guys after we read the chapter, the ChatGPT's breakdown. All right. And it should be the same breakdown that you guys, after hearing the whole chapter, we're about to get into it right now. Okay. So again, welcome. Appreciate you guys being patient so I can have my, disclaimer and we can break this down before we start reading. You gotta have discernment. Again, we're in the book Race Relations in Virginia and Miscegenation in the South, 1776 to 1860 by James Hugo Johnston, right? We go to chapter 8. It's called The Problem of Racial Identity. All right? The intermixture of races had become so extensive by the end of the colonial period that many mulattoes seem to have lost all the distinguishing physical features of the Negro. Dodge the hijack, right? Don't worry, it's going to get into some drop, but we know when to dodge the hijack now, right? It says there were now to be found many individuals classified as Negroes, whom the observer would regard as whites or Indians. Oh, man. Right away, we got the drop, man. You see how me and the ChatGPT broke this down before we even read the chapter, before I even pasted the whole chapter to ChatGPT. This is what we were talking about. Negroes whom the observer would regard as whites or Indians. A traveler in 1788 reports, I saw in this school, Philadelphia, a mulatto, one a Negro. It is impossible to distinguish him from a white boy. Uh-oh. His eye discovered an extraordinary vivacity. And this is a general characteristic of people of this origin. In 1783, another observer reports that in Maryland, there were female slaves who are now become white by their mixture. There are at this time many beautiful girls, many of whom are as fair as any living. and whose posterity must remain in the same degraded condition. Remember the status of the mom, no matter if they were passing for white or even starting to look white or mixing with white. With the passing of the years, the number of such persons constantly increased, and advertisements appeared which contained such descriptions of runaway slaves as, "He has straight hair and a complexion so nearly white that a stranger would suppose there was no Negro blood in him." All right, that's what that runaway ad says. And I've shown these examples, like the actual newspaper ad, we've shown them. And it continues, and a very bright mulatto would be taken for a white boy if not closely examined. His hair is black and straight, or light sandy hair, blue eyes, ruddy complexion. He is so white as to easily pass for a white man. Pay attention. Petitions presented to the legislature of Virginia often mentioned the bright complexion of Negro memorialists. Such quotations as the following are very frequent. "They are so nearly white that they would not be taken from mulattoes where they are not known." If nobody knew that they were so-called mulattoes, they would be mistaken for white. Yo, shout out to Texas 44 Red Lion. Shout out to my big bro. All right, welcome to the club, man. Appreciate it, man. La familia, Cosa Nostra, Talking about the Indio stuff. They are so nearly white. Again, we got that. It says, such persons having more than one half of white blood, though commonly called mulattoes, might more properly be styled quadroons or octoroons. Now they start playing with other words. They start adding other words now. In the lower South, where Indian blood was mixed with that of the Negro, the Indian in the Negro, huh? So who's the Negro again? Remember, what did we just talk about with ChatGPT? Remember, keep that in mind. We got to dodge a lot of hijack while we're reading. That's why I did the disclaimer. Negro could be American Indian. A Negro could be a dark-skinned Black European. Eventually they got reclassified, or, now it's status. Negro again was status too, just like white was freedom. Negro meant bondage a lot of the time. We've gone over this. So, yeah, dark-skinned people, right? Melanated folks over here mixing this in. We find use made of the term griffle. There seems to have been no legal necessity for a definition of the term mulatto until after the Revolution. The states then began to define this word. The acts of the state legislatures may be considered as a part of the effort then being made by the independent American states to transform the common law of England in accord with peculiar American institutions and social ideals. People's ideals and beliefs, right? People's agendas, ideals. Like a politician has ideals, right? It becomes a political thing. Then it becomes a legal thing, right? Then it becomes paper genocide all of a sudden. Then you're forgotten on paper. The action of the lawmakers may also be considered as recognition of the fact that because of the wide extent of the intermixture of the races, what races? The racial identity of many persons had become and would continue to be an important consideration in the American states. So again, most of the focus when they're talking about all this mixture of races, they're just talking about people of color, guys. They're focusing on the color of the people's complexion. Again, because if they have somebody who is a so-called Negro that is passing for white and they don't know he's not a Negro, then they wouldn't be saying nothing about him. But then as soon as they found out then they're gonna include him, right? So-called mixture of the races. He's an octoroon. Oh, you didn't say that before. You knew he had so-called Negro blood, right? You thought he was white. That's what this literally is trying to tell us a little bit, right? In all the states, there was much similarity in the racial laws. The Virginia law of 1785 declared that every person who has 1/4 or more of Negro blood shall be deemed a mulatto. Okay, listen, all colored folks are now mulatto because they're saying Negro blood. What does that mean? They're talking about people, melanated folks. Negro blood. What Negro blood? That could be another Indian they mix with. You see what I'm saying? So we got to be always ready to dodge the hijack and discern through the info. But there's a lot of drop in what they're saying right now. You see how all these people became mulatto? So it wasn't about a mixture between a white European and an African slave, right? It does not, or somebody raped somebody. No, that's not what they're talking about here. Remember, mulatto, the whole history. And the word Negro in any section of this or any other statute shall be construed to mean mulatto as well as Negro, man. That's from William Hanning's Statutes of Laws of Virginia, okay? That's the Hanning law, man, the statute laws of Hanning, man. Come on. That's very scholarly primary. You guys listen, man. So now the word Negro in any section of, right, shall be construed to mean mulatto. So now Negroes, any Negroes mulatto as well as Negro. It's the same thing. So these are laws that put in place. I'm not saying, these are true. I'm just showing you how they're playing around legally with race. It's all legal fiction. That's why the thumbnail says race was a legal fiction. Kentucky became a state. The Virginia definition of the word was incorporated into her law. So they're going with when Kentucky became a state, right? Talking about Negro and mulatto. The North Carolina law on this subject stipulated that all persons descended from Negro ancestors, though one ancestor of each generation may have been a white person, shall be deemed the free Negroes and persons of mixed blood. All right, so again, Negro, white, all terms, right? We need more context. We need to know who the people are. We need to know all these individuals' genealogy. Because as we spoke with ChatGPT and we're starting to see white is being thrown around as well to different peoples. And we're going to watch how this chapter breaks down specifically how white is being used, right? It had nothing to do with complexion. So the North Carolina law, again, on this subject stipulated that all persons descended from Negro ancestors, though one ancestor of each generation may have been a white person, shall be deemed free Negroes and persons of mixed blood. It's all based on color, man. The Code of Tennessee contained a similar provision. Georgia defined a mulatto as one in whose veins there is less than 1/4 of Negro blood. It's all hijack legal stuff here, guys. South Carolina left the term undefined. Florida provided that every person other than a Negro who shall have 1/4 part of more of Negro blood shall be deemed a mulatto. Huh. Alabama declared that the term mulatto or person of color within the meaning of this code is a person of mixed blood. Huh. Descending on the part of the father or mother from Negro ancestors to the third generation inclusive. The one ancestor of each generation may have been a white person. but then you got to have this in case this, but then the grandma got to be this, and then the granddad got to be Negro, and then the grandma got to be white, and then the third, fifth great grandpa got to be Indian, then, it's all hijack, guys. It's crazy how this has made it to law, like these crazy explanations, like hijack explanations, trying to give a foundation to words so they can apply them to you, like make them like real when they have no real meaning when it comes to origin or ethnicity of people. So Mississippi enacted that every person other than a Negro whose grandfather or grandmother is or shall have been a Negro, although his progenitors except that descended from that Negro, shall have been white persons. Say what? Yeah, what the? Oh, man. Who shall have 1/4 part or more of Negro blood, shall in like manner be deemed a mulatto. Wow. It will be noted that in no case does the law provide that a person having less than 1/8 of Negro blood shall be deemed a mulatto. Now, again, I'm going to tell you, like I said the other day, who's really in a lab measuring the blood quantum and really like breaking it down and who's really going off that, like, this is made up stuff, guys. A lot of it is based on visuals. It's going to even admit that in this chat. It's going to admit that. It's all visual. Like a lot of times just visually. And social ideologies, as I said earlier. It will be noted that in no case does the law provide that a person having less than an eighth of Negro blood should be deemed a mulatto. It would appear that the lawmakers of the early national period feared that a declaration to the effect that the possession of any Negro ancestry, however remote, made a man a mulatto, might bring embarrassment on certain supposedly white citizens. Supposedly white. Oh, no, no, you can't say the mulatto. No, no, that would dirty their blood, huh? Supposedly, right? How many people pass for white? Like forever. No doubt it was also believed that it would be exceedingly difficult, if not impossible, to enforce a more drastic law. So, especially when a lot of times, again, it was just status and not complexion. So, the attempt to apply the laws that had been enacted illustrates the difficulty under the system as adopted of determining who were white men. Listen, it was difficult under the system as adopted. What they're creating, this hijack system they're creating, now they got to try to prove, and it's becoming difficult to prove or just give it as an exact origin to people, right? Who were white men and who were mulattoes or Indians or Negroes? Uh-oh. But if we think about that today, we'd be like, how could they be how could it be difficult? A white man is a white man and a Negro is a Negro, an Indian is an Indian, right? A lot of people that don't know anything, right? Oh, how could they be? How could they? How difficult is it? Because it wasn't about complexion, guys. Many cases are recorded in which the courts were asked to determine the race of the individual. Such cases were submitted to a jury, which was expected to determine on inspection whether the person posed more than the limited degree of Negro admixture. Wow, that's crazy. So basically, you got a jury deciding whether you are Negro or white or mulatto. No matter if you know who your grandparents are, no matter if you got all your family there telling them, nah, man, what you talking about? He's us. Like, it don't matter, man. The jury decides. You guys hear that? In 1806, a case of this kind appears in Virginia. In this instance, the judges rendered an opinion that where white persons are claimed as slaves, right? You see that? Where white persons are claimed as slaves, the onus probandi lies upon the claimant. It is said that the distinguishing characteristic of the different species of the human race are so visibly marked that those species may be readily discriminated from each other by inspection, and that in the case of a person visibly appearing to be of a slave race, it is incumbent upon him to make out his freedom. Wow, that's crazy. So if they, when they say inspection, they're saying when they see you, when they visually, they just looking at you, when they judge you based on appearance, basically, literally judge you, because this is a court case, this is a judge literally judging you based on appearance, literally, right? If he said, if you visibly appear to be from the slave race, what does that mean? There's no such thing as a slave race. Like, where you can say, oh, yeah, they come from this country specifically. That's their name of that's their. Nah, listen, man. Many people were enslaved. Indians, Europeans, North Africans, some West Africans here and there in their own land, all over the world. All over the world, man. All right. Some may say it comes from the Slav. Could be, but that's not what they talking about here. You come from the slavery, they meant you look so-called black. If you have some color in you. So it is incumbent upon him to make it. Now you gotta prove your Negroness or your whiteness or your freedomness. Because if you know you are from your family's black folks, but you don't call yourselves black at that time, like you Indians, you Irish, whatever you are, Highlanders, you Indians, Muskogees, whatever, Creek, you know, if you already know that you don't even want to become white either, but if that means freedom, then you might fight for that. Actually, you might want to actually pass for white if that gives you more liberty. Unfortunately, a lot of people did that, for the benefits, for the convenience, right? and also, not to be harassed so much like this. It says the case of certain Nanny Paggy gives an interesting example of the difficulty of enforcement and of the mistakes that were possible under the Virginia law. The girl was bought in North Carolina as a Negro slave. There were doubts as to her race at the time of her purchase. Remember, Negro don't that can't tell us what origin, where is she from? Remember. So now they're like, well, what is she? When they bought her, they didn't know, but she was treated as a slave and compelled to marry, or rather to cohabit with a Negro, with another Negro. Again, what Negroes? What's his name? Show me his genealogy, by whom she had several children. This case became the subject of a long and tedious litigation, but in course of time, the jury finally reported, "We find, therefore, that the plaintiffs are free persons and not slaves, and we find for them 1 penny damages." What? They gave him a penny? Hold up. What years was that? 18. So 1700s. They gave her a penny. I mean, I guess it was a lot back then. That don't sound like a lot still. It says in those cases in which the individual claimed that his dark complexion was due to Indian, oh, rather than to Negro blood, the jury was asked to determine this matter also on inspection. Oh, body bag for the illusion. Shout out to all the real ones out there, man. He said, I'm dark skinned because I'm an Indian, man. Not because I'm a Negro. Copper colored tribes, man. Dark complexion was due to the Indian, rather than to the Negro blood. The jury was asked to determine this matter also on inspection. Now they had to decide. Now it's up to them. Now deciding now whether now we got to trust the people, right? Now we got to trust the jury to decide this person's fate. When he's telling them he's Indian. He's making a point. He's not literally saying that he's not maybe could be classified as Negro or considered Negro or from Negro folks, but he's an Indian. He's not trying to be called a Negro. He's like, I'm an Indian, man. I ain't dark because I'm from whatever you're trying to make me, Africa or Negro, whatever you're trying to make me. So in North Carolina, also, there are found recorded cases in which the courts were asked to determine the race of the individual. A case reported in 1802 recites that the plaintiff, when an infant apparently about 8 years old, was placed in a barn by some person unknown, that the defendant, then a girl of about 12 years of age, found him there, conveyed him home, and has kept possession of him ever since, treating him with humanity, but claiming him as her slave. Damn. The plaintiff was an olive color, between black and yellow, had long hair and prominent nose. Olive color. Olive color. All right. I'm glad we live, I'm glad we live. Hold up. I want to show you guys something real quick. We're talking about olive color, right? We got to know how to dodge the hijack. All right. This is from one of my upcoming books. I know a lot of people probably going to steal this. People are going to steal it. I know. It's all good. All about Spanish olives, man. So let me just zoom in real quick, right? We're talking about olives, right? Spanish olives, right? Brownish, reddish, dark, black, olive color, red, yeah. Olive. All about Spanish olive, okay. Right? That's usually the ones they refer to Spanish olives in a lot of the so was it of olive color between black and yellow? Between black and yellow, right? You get what they're saying? Had long hair and a prominent nose. Prominent nose. In this instance, the individual, though obviously of a dark complexion, right? Obviously, of a dark complexion, if he's the color of an olive, yeah, obviously, right? Brought suit for freedom. He said, he's suing. He wants his freedom, and he won his suit. The court declaring such persons may have descended from Indians in both lines, or at least in the paternal. So his paternal Indian lineage gave him his freedom, man. At least, you see, they were trying to make him a Negro, so-called black, and then enslave him because of that. You see, so you disfranchise, they detribalize you, disfranchise you, then reclassify you. Now you are property. They own you now. Now you have you lost your freedom because you lost your sovereignty. In 1828, the above decision was reaffirmed, although the plaintiff this time appeared to have been a mulatto rather than an Indian. He's a mulatto. He's not an Indian. That's the hijack. Indians were called mulattoes, man. That's the hijack, man. So that's what they said in 1828. They're like, nah, man, he's a mulatto, man. In 1842, a mulatto and a white woman were tried for fornication and adultery. Oh, man. What white person? What mulatto? The persons had been married and lived together as man and wife. They could have been of the same people, guys. This is what I'm saying. This is what I'm trying to make you understand. They were happily married, right? And lived together as man and wife. But in this case, the marriage was declared illegal. Wow, that's messed up. And the husband was declared to be a mulatto when it was proved to the satisfaction of the jury. There's people deciding this. This is crazy that one of his grandparents had been black. Actually, I dug around. He went snooping around. He's trying to get. I knew it. He's a black. I knew it. The grandparent could actually be an Indian, right? And that's the irony behind it, and that's the most messed up part about it, right? So in 1849, a free mulatto was accused of possessing firearms, contrary to the law of North Carolina. Huh. Free mulattoes can't have guns, man. If you look like a mulatto, man, you can't get guns, man. That's crazy. This individual contended that the law did not apply to him because of the fact that he was or less than the prescribed degree of Negro blood. Wow. So how was people really proving that back then? Hey, man, take a sample of my blood. Go do the blood work, man. Go do the blood work, man. The following testimony was offered in this case. So again, it could be a brothers, right? Light skin, one very dark skin, and literally the jury's deciding that the light skin one, yeah, he can pass for white. Yeah, he can carry a gun. Oh, the dark one, don't give him, don't give him a gun, man. All right, mulatto. All right, we'll call him the mulatto, but still don't give him a gun because free mulattoes can't have one either. He got to be white, so-called white. This individual contended that the law did not apply. Okay, so he got, I ain't Negro, man. The following testimony was offered in this case. So this is what he says, on behalf of the state, a witness deposed that he formerly knew one Barnes Castle, who was a very old man and died some years before the institution of the prosecution. That the said Barnes Castle lived many years in the neighborhood of the defendant's father and his family, and that he, the witness, heard Barnes Castle say that he knew the paternal great-grandfather of the defendant, who was called Joseph Dempsey, alias Darby, and that he was a coal-black Negro. Wow. Again, they're going off complexion, not ancestry or genealogy. Just want to make that clear, you see? So they say, oh, they found out that one of his great grandparents was very dark. So what? You get it? Like they just because they had, right? Coal, they going a little crazy with it, saying coal black Negro, right? Nobody's like coal black, you know. To the admission of this evidence, the defendant objected, but the court received it. The defendant gave evidence that the mother of Joseph Dempsey, the great grandmother, was a white woman. So they're like, nah, but look, he got a white great grandmother right here and another. Like they go, all right, how many? So it's funny because I don't know if they kept going, but like imagine, like, all right, let's see how many great grandparents are white and how many are so-called black. Let's see which ones win to determine what you are. That's crazy, right? That would be crazy, right? This is what I'm saying. They're playing with people. This is fictional race, right? So the defendant gave evidence that the one of them was white, right? And that the said Joseph was a reddish copper colored man. The said Joseph was a Joseph Dempsey body bag. I told you. See, this is what I'm saying, man. First they're saying he's cold black Negro, right? Now, now they're literally telling us Joseph was a reddish copper colored man with curly red hair and blue eyes. They made us think something totally different, right? You see what I'm trying to tell you? Same Joseph Dempsey, right? Alias Darby, right? Yeah, Joseph was a reddish copper colored man. You see how they just changed them in less than in a couple of sentences? Wow. That the said Joseph Wise was a white woman and that they had a son named William, right? Again, so-called white. That could be an Indian woman. That could be somebody passing for white. That could be white based on status, not complexion, meaning she's free, meaning her status is, elite or, in social standing or whatever. And their son, again, named William, that the said William also married a white woman and had issued by her a son named Whitmel, and that the said Whitmel married a white woman. So if they kept going lighter and lighter, if that's what they mean, then yeah, eventually that did happen too. They married a white woman, and that they are the parents of the defendant. So again, but all these could be white based on category status. In this case, the court declared that the man was not a mulatto and that he therefore had the right to possess firearms and to exercise all the rights of other white citizens. All right. He got to become white, basically, is what they're trying to tell you. The court allowed him to be or pass as white or become white in status. But he descends from black folks, guys. Copper colored man. They're saying he was coal black Negro, but actually reddish copper colored is what they meant. The court also declared that it could hardly undertake itself to construe the expression person of color so as to bring one within the statutes, creating felonies. Oh, creating felonies or otherwise penal merely because he derived from some remote ancestor a tinge of color that was not white. There you go. Okay, this whole paragraph got to get highlighted. Okay, based on perception, physical appearance only because of his color. You see? So what? They're looking for any reason to disfranchise any person of color. In a North Carolina decision rendered in 1859, we find interesting evidence of the apparent necessity for the use of excerpt testimony to determine racial classification. This is another case of the attempt to possess firearms. In this case, the state called in an expert who deposed that he was a planter, an owner, and manager of slaves, and had been for more than 12 years, that he had paid much attention to and had had much observation of the effects of the intermixture of Negro blood with the white or, look, white or Indian races. So you see how they're interchanging white with Indian, meaning free, Negro, status, bondage. And that from such attention and observation, he was well satisfied that he could distinguish between the descendants of a Negro and a white person, and the descendants of a Negro and an Indian. And further, that he could therefrom also say whether a person was full African or Negro or had more or less than half Negro or African blood in him, and whether the cross was white or Indian blood. All right, so they got an expert, right? They got this guy, I said expert, my fault, it's expert. They got an expert, right? Deciding who's what, right? Oh, he's white, he's Indian, he black, he Negro, he Mexican, yeah, I don't know what he is. He black, he Negro. Oh, wow, oh, that one, I don't know. He's the expert though, guys. A person is decided based on appearance. This was really happening in American courts. This is how why we live in the situation, why you live in the situation you live in, why we all live in the situation, why we all live in a hijack society. This paper genocide is real, and how they're classifying people this way, right? They got an expert. I can't believe that. Legal fiction. Legal fiction. In the decision of the court, it is to be observed that in the determining who were white, Negro, or Indian, North Carolina possessed experts far superior to Lord Leo's or Agassiz. The court declared as follows, right? So they got these experts again. The effect of the intermixture of the blood of the different races of people is surely a matter of science. It may be learned by observation and study, nor does it require distinguished comparative anatomists to detect the admixture of Negro or Indian with the pure blood of the white race, so-called white, right? Any person of ordinary intelligence who for a sufficient length of time will devote his attention to the subject will be able to discover with utmost unerring certainty the adulteration of the Caucasian with the Negro or Indian blood. Mr. Leal, in common with tourists less eminent, but on this subject not less misinformed, has somewhere stated that the Negroes in America are undergoing a manifest improvement in their physical type. He has no doubt that they will in time show a development in skill and intellect quite equal to the whites. All right, so again, what do we see there? We see that whoever this guy is writing, he's racist. White superiority. Like this is very racist. All right? See what he's trying to say? But we're just reading it so you guys can get the whole context of how you got this far in the hijack with your reclassification and paper genocide. Social ideologies, remember, people's social, this expert is a white superiority believer, like very racist. This unscientific assertion is disproved by the cranial measurements of Dr. Morton after admitting some physical improvement on account of the increased comforts with which the Negroes are here supplied. The author add 1 or 2 generations of domestic culture effect, all the improvements of which the Negro organism is susceptible. Wow. Racial, racist ideologies. Wow. And they even like talking about ethnic cleansing, literally. We possess thousands of the 2nd generation and many more Negro families of the 8th or 10th generation in the United States, and were unadulterated with white blood. They are identical in physical and intellectual characteristics. No one in this country pretends to distinguish the native son of a Negro from his great-grandchild, except through occasion and ever apparent admixture of white or Indian blood. While it requires the keen and experienced eye of such a comparative anatomist as Agassiz to detect structural peculiarities in a few Negro-born slaves, the improvement among American-born slaves noticed by Mr. Leal in his progress from the South to the North are solely due to those ultra-ecclesiastical amalgamations which in their illegitimate consequences have deteriorated the white element in direct proportion that they are said to have improved the black. We believe that it would often require an eye rendered keen by observation and practice to detect with an approach to certainty the existence of anything less than 1/4 of Negro blood in the subject. He may be a person who has only a 1/16 of African blood in his veins, the ability to discover the infusion of so small, blah, 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 blah. Okay, I think I read too much. My fault, guys. You guys see, I just wanted to get that clear. Like, you guys, who's deciding? This guy, the same person who just said all that hijack, racist, all that, hijack, like really bad shit. He was deciding people's fate, people's race. Having examined the evidence used in the study, I am not able to concur in the opinion of the learned judge. In South Carolina, also as shown by the records of the state courts, racial identity became an intricate problem. Here again are to be found individuals who had associated with and were regarded as white persons. But when unfortunate circumstances involved them in legal proceedings, they were challenged because of the tradition or suspicion that they had inherited the blood of the Negro. and hence could not exercise the rights and privileges of white persons. All right, all their hijacks now, disfranchisement. The following case shows how doubtful the racial origin of supposedly white persons might be. Supposedly white. So now he's pointing out that a lot of these white people they're allowing to have all these rights and privileges might not be so white. The tax collector of St. Paul's issued his execution, which was about to be enforced by Sheriff Rice against the relators as free mulattoes or realtors. They applied for and obtained a prohibition nisi on the grounds that they were free white men, but were ordered to declare in prohibition. Two of the brothers, Thomas and John, were in the court and submitted themselves to the inspection of the jury. Their full brother Henry, who proved to be a darker man than either of them, was not present. All right, so they told the dark skinned brother to not go to court that day because if you go, they're gonna know we so cold black. Pay attention what literally they're telling you here. So he was not present, and his absence was counted for in this way. He is the overseer of the Colonel Perry of St. Paul's, and that he could not attend court. Sally Johnson, the mother, was not at court. Whether her presence was required by the respondents was not shown. Her sister of the whole blood, Mrs. Patrick, was shown to the jury, and from inspection, I should say, was a quadroon. This is crazy. The father of the relators or realtors, Benjamin Johnson, a white man, so-called, right, white, proved the realtors or relators were his children by Sally Johnson. She was the daughter of Lydia Tan by John Eric Miller, a Dutchman, right? They're saying white man, right? But white in status, that could be a black Dutch. So-called Sephardic Jew that came from Amsterdam, that's where they had their base. Her second husband, Lydia Tan's mother, was a white woman. Her husband, Tan, was a colored man. All right, so you see, these are tags. Nobody, so far throughout the whole reading, when we get these tags, nobody's talking about ethnicity, guys. Ancestry, genealogy. We're talking about what people think of people's appearance or what they know of their status, legal status. According to this genealogy, the relators could not have more than 1/8 of Negro blood in their veins, possibly not so much as 1/16. So people were literally trying to go to court, say, but yeah, I'm a Negro, but it's only it's 1/8, 1/16 is very little, you know. So they were it was crazy back then, guys. That's what people had to go through, man. You know, I can't judge anybody. I don't know, you know, we weren't there, but that's what they were going through, man. That's what a lot of you folks were going through. The decision of the court was that these people should be classified as white persons. So they got legally, no matter if they came from black folks, black Europeans, black Indians, so-called black, right? Colored folks, if they came from colored folks, melanated people, people of color, Indians, they became legally white. They beat the case. It says in 1850, we find a similar case. In this instance, a witness was challenged as a free person of color. After much testimony to the effect that the witness was and was not of the prescribed degree of Negro blood, they're saying African, right? It was finally agreed that he should be considered as a white person. She should be a white person. After being a free person of color, right? Like these are people they know, but they somehow beat their cases, right? The record in the two cases cited above shows that the persons in question were of the poor white element of society, but the following case seems to offer evidence that Negro blood might be found in the higher ranks of South Carolina society. Of course it did, because South Carolina was a free people of color city from its initial start and forever. People of color, Indians and black Europeans. We've gone over this. We got a lot of videos on South Carolina. Who were the biggest slave owners? Yeah. So, okay. So it says here, an important case was presented to the court, but on the trial of two of the principal witnesses were objected to on the ground that they were persons of color. An issue was made, and the question was submitted to the jury. It appeared that the father of the witnesses was a white man, and the mother a descendant in the third generation of a half-breed who had a white wife. Again, this is all people's judgments and tags and terms. Their mother's father was the issue of this marriage, and he also married a white woman, so that the witness had 1/16th part Negro blood. Again, they're going off shades of complexion. This is crazy. The maternal grandfather of the witness, although of dark complexion, had been recognized as a white man. All right, the dude who's dark complexion, the witness, but he's recognized as a white man in status, legal status. Received into society and exercised political privileges as such. Okay, he got to pass through white and got all the privileges and benefits, right? His legal status as a white man, even though he's a dark complexion man, even though he's so-called black. Their mother was uniformly treated as a white woman, and their relations of the same admixture have married into respectable families. And one of them has been a candidate for the state legislature. The witnesses were ordinarily fair and exhibited none of the distinctive marks of the African race. That's the hijack. They don't look like what's an African? Africans look different. See, that's the thing you gotta understand, guys. All Africans don't look the same. Shout out to Texas 44 Red Line. Shout out to Rob, man. All people in different countries don't all look the same. Ethiopians don't look all the same. Africans don't look all the same. And whatever look they're trying to make African is not exclusive to Africa. Remember that. So this whole thing is hijacked. I'm just reading this so we can understand the history, right? And discern through it and have our own and understand what happened. Because if we don't learn from history, we're going to repeat it. It says they are respectable, have always been received into society and recognized as white man, okay? Hey, they've always been white, man. Don't try to make them black now, man, all right? We want them to be white, okay? One of them, militia officer, and their caste has never been questioned until now. Yeah, the audacity, man. He's never been questioned. How could they question him now? Everybody knows he was dark. Nobody said nothing before. This is what I'm trying to tell you guys. That's how it is. It says the opinion rendered in this case by Justice Harper shows that it was necessary to take a very broad interpretation of the term mulatto. The opinion reads as follows. We feel no disposition to depart from the rule laid down in the State versus Hannah, Bailey, and 558. The ground for that decision is that neither of the several decisions which speak of Negroes, mulattoes, and persons of color, nor the Constitution of the state, which restricts political privileges to free white men, give any definition to those terms. All right? They don't explain what those terms mean, no definition for those terms, nor is there any known technical meaning affixed to them. We must of necessity then suppose them to have been used in their ordinary and popular signification, and to the ordinary and popular signification we must resort for the interpretation of the laws. From what possible source could a definition be drawn that would make a person generally reputed to have been a free white person, a mulatto, or person of color? Indeed, it would be an absurdity in terms to say that such a one is, in the popular sense of the word, a person of color. Free white person, mulatto, person of color. On any mixture of Negro blood, however slight or remote. We should be making, instead of declaring a law, and making a very cruel and mischievous law. It is this which makes the question peculiarly proper for the jury. It belongs for them to settle questions of common usage and the meaning of popular terms, though their decisions may be matured into rules of law. The principal argument urged against this rule we have adopted is its want of precision. We cannot say what admixture of Negro blood will make a colored person exactly. Pay attention. This is, guys, this is the other side of, right? The defendants, right? The principal argument, so they don't know what, exactly what he said. What admixture of Negro blood will make a colored person? And by a jury, one may be found a colored person, while another of the same degree of blood may be declared a white man. Exactly. Exactly. If you're basing it all on perspective, we're gonna run into a lot of hijacks. We might mess up. We might commit errors based on our perceptions and stereotypes and prejudices and racial views, social ideologies. And we got to stop that because we continue to do that today. A lot of us continue to do that today. But they were doing this in court back then. This is crazy. Now it just happens all over the place. We got to have patience. That's right, Texas. You know, it's all, everything, change is coming, guys. Look what we're doing. Look what we're teaching, right? We're adding a lot of context. You know, this is going to somehow make a difference. So, in general, it is very desirable that rules of law should be certain and precise, but it is not always practicable, nor is it practicable in this instance, nor do I know that it is desirable. The condition of the individual is not to be determined solely by distinct and visible mixture of Negro blood, all right? Not by his appearance, but by reputation, by his reception into society. Huh? But by status? And is having commonly exercised the privileges of a white man. Oh, if he lived like a white man, he did this like so he could, let's make him white. Let's judge it on that, not on color. Huh? But his admission to these privileges, regulated by the public opinion of the community in which he lives, will very much depend on his character and conduct. It may be well and proper that a man of worth, honesty, industry, and respectability should have the rank of a white man. Pay attention. So now they're paying more attention to your status as an individual, if you're wealthy, if you who your family is, right? Now, oh, let's make him white. So he could have a brother that's broke. His brother could be broke. He could be a drunk. They're like, nah, let's make him a Negro, a person of color. You guys understand what they're telling you here? This is real history. While a vagabond, right, which could be his brother, right? While a vagabond of the same degree of blood could be his family, should be confined to the inferior caste. He black, make him black. It will be a stimulus to the good conduct of these persons and security for their fidelity as citizens. That's crazy. It's crazy, man. A lot of drop going on right now, man. It says the court therefore declared these persons to be members of the white race. Either way, let's just make him white. Because he got good standing. Don't matter if he's so-called black. No matter if he's a Negro. No matter if he's, what they're saying, coal black or reddish copper color. Don't matter. He got money, he got wealth, he got connections, he got this business we like. Yeah. Yeah, he's a Freemason. Yeah, let's make him white. Hey, man. Hey, connections, man. In 1856, a Georgia court decreed that one Joseph Numes, all right, we got another case here. These are all kind of crazy cases. Watch this. It says Joseph Numes was to be a white man and not a mulatto, deprived of the rights of a free white man. In this instance, Joseph Numes was shown to have been the descendant of early Spanish settlers of West Florida. I'm sorry, man. I'm going to go into like, this could be possibly a crypto Jew, crypto Muslim. Who's the early Spanish Huguenots? Who's the early Spanish settlers? Come on now. Right? But it was shown also that among his ancestors, there were included both Indians and Negroes. Body bag for the illusion. Yo, shout out to all the real ones out there, man. You guys understand what this is the history we've been showing all these years, guys. Summed up into a little paragraph. Indians and Negroes, that cancels out. What Negroes? Who's the Negro, right? You're just talking about color. Okay, so Indians. So Spanish and Indians. That's his ancestry, guys. Most likely dark complexion Spanish and dark Indians, dark complexion and copper color. Like, see, this is what I'm trying to tell you, right? And now he becomes mulatto. Remember mulatto, two people from different nations mixing, not color. All right? Joseph Numes, so-called black man. I don't care how you want to look at it. It's so-called black man today. He would be called black man. All right? Numes was a man of great wealth. He had always associated with white men or the white elites or people classified as white. Remember, that could be a lot of passing white folks and people just white based on status. And he was regarded as a white man by his associates. However, when he died, it was found that his property had been willed to his natural children by a mulatto slave concubine. Those who wished to secure his property investigated his pedigree and discovered his remote Negro ancestry. Oh, man, that's funny, man. I found that he was Negro. He was fooling us, man. He was saying, he told us he was white, man. Nah, it wasn't, nobody had to tell him. He was white because of his wealth, his status, guys. They knew he wasn't no, not in, he was never in bondage. He was never so-called Negro in status. That's why when they realized an actual somebody in his family was declared that categorized as Negro, like, damn. They then possessed themselves of numerous property. So because, listen, he was all good. Listen, he was the talk of the town. That was everybody's boy. Like he socialized with everybody. He had great wealth. As soon as they found out, as soon as they could hijack his and reclassify him, as soon as they could do that in some legal way, they took possession of his property. That's what they wanted. And sold the mulatto children and sold his children. That's messed up. That's so dirty. That is so dirty, 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 man. That's real life stories right there, man. That really happened. Indian ancestry, right? And Spanish, right? And then his wife, mulatto. His kids were like, she could have been Indian too. Like, this is what they doing. That's so messed up. They sold his children. The lower court supported them in their action, holding that since Numas was a mulatto, now that he's a mulatto, he's no longer white. Now they found out something about him. Now everything changes now, huh? The will was void according to the laws of Georgia. Wow. In Alabama, we find two instances in which the court directed that person supposedly white, right, should be classified as colored and be denied the privileges of white citizens. White citizens. In 1859, Seaborn Heath resisted arrest by certain William Chavis, constable of Ottawa County. The Chavis, they Indians too, man. Says he claimed that the constable was a mulatto. So this mulatto, who's William Chavis, like I said, the Chavis are Indians. They go back to a lot of Indians, the Chavis family. Catawbas, Saponis, Eastern Siouan. So he was a mulatto and hence disqualified for the functions of that office. Oh man, he got disfranchised. Now his rights got taken away based on what they're trying to classify him as. Heath, Heath was able to show that the great-grandfather and the great-grandmother of the said Chavis were both mulattoes. And again, that don't mean nothing, guys. That could be Indians, Black Europeans, that don't mean, like, this is what I'm telling you. That's the hijack. We broke down the whole mulatto origin and the usage throughout the years. So you guys see all the hijacks on top of hijacks on top of hijacks that then they use for court later on. That's crazy. Again, fictional laws, fictional race laws. Or legal fiction. Legal fiction, basically. The court sustained the contention of Heath, reversed the decision of the lower court that had considered Chavis a white man. The lower court had already said, yeah, he could be white. And the former constable was now classified as a person of color. Party bag, paper genocide, and disfranchisement. Because on top of that, they like, now he can't work. Like, they literally messed up his career. Like, wow. Social conditions under the early Spanish regime complicated racial problems in lower Alabama. In 1859, the supposedly white children of certain Clara were offered as witnesses in murder trial. Much evidence was offered concerning the ancestry of these white children, right, in parentheses, but they were not permitted to testify for they were finally declared to be mulattoes, who, of course, were not able to bear testimony against a white man. That's crazy. You see how now their laws get in the way of things properly being done because now they, oh no, and it can all be related. It's crazy. In this instance, the court accepted the evidence of certain William Fisher, who was a gentleman about 60 years of age and a Creole born in the city of Mobile. A Creole of Mobile, huh? Alabama, and who testified that Clara, her mother, and probably her grandmother, who was named Jean Seymour, were born at 20 Mile Bluff on the Mobile River below the 31st degree of north latitude and had always lived there. That Anastasia, the mother of Clara, was about this age. Oh, sorry, his age, but he did not distinctly remember Clara's age. That Jean Seymour was a Griffey, dark in color, but not entirely black. No one is. That Anastasia was the daughter of a white man, so called, right? Simon Andre by name, who always lived with Jean, and her husband, that they were called man and wife in Spanish times before the change of flag, and had several children who were all about the color and appearance of Anastasia. That Jean never had any other husband than the said Simon Andrew, and everybody recognized her children as his. That Simon Andrew and Jean had both been deceased for many years. That Anastasia's only husband was a white man named Chastang. That don't sound like a white man to me. But anyways, who was the father of Clara? That Clara was recognized by everybody as Chastang's child, and her children were by a white man. That these colored women always were free and owned slaves. They owned slaves, right? Black slave owners, so called, and other property, that they were treated as husbands and wives under the Spanish law. And again, that could just mean family that they had working under them, or just neighbors and people, indentured servants, like a lot of the stuff is also taken out of context. But yeah, that happened. Yeah. Colored folks had farms, guys. They needed work, farm hand, and needed a lot of skilled people to run certain things, all that. It says in this area there is much evidence of the mixture of the Indian, Mexican, Negro with that of Spanish, French, and English. Okay, so Mexican could be Indian, right? Negro could be Indian. And all the Spanish and French and English mixed with the Indian. So this is what I'm saying. I have context, all right? So the mixture of all these people, okay. These could all be people of color too. That's the other thing. Don't think, right? It says in the courts of Mississippi and Louisiana, the state was asked to determine the race of persons supposed to be mulattoes because of their dark complexion. They're supposed to be mulattoes, but they're kind of dark, they're saying. Again, the courts of these states held that such persons might be descendants of Indians or Mexicans. Again, all Mexicans don't look the same, guys. Mexico is a country with a melting pot, different type of looking people. We have to, that's one of the things I should have laid out as a disclaimer because I didn't know they were going to bring up the term Mexican in here. But I get it. People born in Mexico. I think that's what they're saying, right? Right? So, but the complicated mixture of racial blood in this section of the United States was made decisions as to pedigree more difficult. In Tennessee, we find legal problems similar to those described in other states. Mention may be made of many other cases of pedigree not above described, which proved equally difficult for the injuries and judges of the southern courts. In northern states, similar problems were presented to the courts on those occasions in which free Negroes attempted to enter the public schools. The study of this subject leaves one with very serious doubts of the absolute purity of the Nordic blood. Okay, so we got another hijack coming. Beware. So, and ChatGPT is gonna point this out when it gives the summary at the end, right? So now he's using Nordic to be in white. So what he wants to make white Nordic. He's trying to say the pure white. He's talking about pale skin, like what people he wants to call that Nordic. Okay, just so you understand, that's the hijack. If you want to talk about the Nordics, a lot of Nordics, mostly original Nordics, were people of color as well, and we've shown the sources, the anthropological, ethnological books, old books, primary sources, right? scholarly works here. It says, where were we? So the study of this subject leaves one with very serious doubts of the absolute purity of the Nordic blood of the southern states. What Nordic blood, huh? The refusal of the lawmakers of any state to enact that any degree of Negro blood prevented the individuals being classed as a white person may be interpreted as an admission that if such a law were passed and applied, it would prove very cruel and mischievous. In certain sections, persons of dark complexion were avoided because of the suspicion that they were of Negro ancestry. So they're like, oh, hey, let's not mess with him. He's kind of dark, so we might find out he's black. So let's leave him alone, man. Let's leave him alone. The accompanying note seems to show that there were elements of the population that might have been led to believe rumors, right, that prominent men were of Negro extraction. Uh-oh. Uh-oh. Prominent men were of Negro extraction. Oh no. The record of cases that were carried to the higher courts as using the above evidence may be considered as proof that in many unknown instances, acting on such precedents as these courts had established, right? Individuals having less than one-fourth degree of the prescribed blood passed from the class of mulattoes into the ranks of the white race. The records of the Hustings Court of Petersburg, Virginia, afford an example in the case of a certain Sylvia Jeffers. In 1814, this woman was emancipated by the will of her deceased master, who was also the father of her children. All right. That's her husband, basically. That's her man. That's probably her. Come on now. You know, legally, he probably can't marry her because he's declared white, remember? So they just, but that's probably family here. A lot of the time, this is just family, not a evil white slave master raping somebody. Okay, that's just what, you got to leave that other possibility open too. The record of the Hustings Court of Petersburg. Okay, we got that. She was emancipated, father made children. In 1853, she and her children presented themselves before the court of the city and claimed to be entitled to the status of a white person. So now she's fighting for her rights. All right. The court granted her petition, and legally, these persons were no longer mulattoes. They agreed. They say, okay, you can be white. Yeah, you got good wealth. Your husband and this, yeah, he got, yeah, he's good. We cool. You're good. You're good. All right, see you later, man. You white now. I white. The court granted her petition, okay? No doubt other examples of legal passing into the white race might be discovered. There's many examples of this, many examples. While it was possible to pass from the Negro into the white race according to the law, there was a much larger possibility that such passing went on to a much larger extent. Passing for white actually was of large scale, massive extent, larger extent without thought of or resort to the courts or legal procedure. No one can ascertain the extent of this process. For those who attempted to pass out of the mulatto group had good and sufficient reasons to conceal the status of their ancestors and attempted to cut themselves off from all associates that knew their ancestral record. So it kind of helped in the paper genocide eventually, like, not because now you're going with the benefits and convenience of being white. You didn't want to be disfranchised, and I get it. But the fact that light mulattoes in many classes attempted to gain the privileges of white men and throw off the restrictions of the mulatto is revealed in instances in which discovery was made of such action. The records of the courts of Louisiana show that in 1852, a slave, a slave being well dressed and of gentle deportment, took a cabin passage on the steamboat Western Road going from New Orleans to the Western country, crowded with passengers. His color was a shade lighter than that, sorry, yeah, than that of a new saddle, with clear skin. And his hair dark and straight, sorry. He sat at the first table in the cabin near the ladies. His appearance did not indicate African extraction or what they're trying to say, Negro, right? But that of a person born in the South and exposed to the sun, a Mexican or a Spaniard. No person suspected his Negro blood. He looked Hispanic, That's what they're trying to say. He looked Hispanic. All right. They didn't know he was Negro. Until near Memphis, the steward of the boat expressed his suspicion, and a clear Christman was had, and the master of the boat took the responsibility of delivering him to the civil authorities at Memphis as probably a runaway slave. Wow. All on his appearance, they're like, yo, they turned him in as a runaway. They judged him straight up. He was brought to New Orleans and sold at auction. Wow. The auctioneer, and another thing, the discovery of his Negro blood might have been easily made. All discoveries are easy after they are made. The passengers on a crowded boat did not make the discovery and travel in 700 or 800 miles with him, although he sat at the head of the table. Although one of them says he had the appearance of a modest, unassuming gentleman, another represents him as a freely mingling with society. Even after discovery, many thought the master to blame and acting without more indications of color or proof. Oh, some people are complaining. I was like, yo, he was cool, man. He was dressed good. Like, I didn't care, man. He looked white. He could pass, let him be white, man. Like, he was cool, man. How do you even know he had Negro blood? Where's the evidence? They just took him in. Like, they didn't do no genealogy or blood work or nothing like that, right? They based it all on his appearance. So in this case, sorry, we think he boldly incurred risk for the benefit of an unknown master. In this case, the court held that masters of Mississippi steamboats were not responsible for the racial identity of their passengers. The semi weekly Mississippian reports the case of George R. Shaw. We got another case here. Convicted of the court of Pittsburgh as a kidnapper. So I hope you guys enjoying the reading. This is a lot of good drop, today. A lot of things to discern and, have as foundation to know, you know. Thanks for tuning in. Shout out to everybody in the live chat. The offense of which Shaw was found guilty was that of kidnapping. Though the proof and the charge of the judge did not warrant the jury in finding such a verdict, a very white Negro belonging to Mr. George C. Ragland, a very white Negro, a white Negro, George C. Ragland of Tuscumbia, Alabama, had run away from his master and settled in Pittsburgh as a white man. He became a white man. And under the name of George W. Ferris, he took on a whole new name where he married. So imagine that now he has a whole descendancy, right? And now, modern times, the family is doing the genealogy. They found out, yo, my grandfather changed his name, man. He was a Shaw, man. He changed it to Ferris. And a lot of you guys run into this stories in your family or in the genealogy. You don't know what's going on. But these are some of the examples of what's going on. This is a good example of that. And a lot of you know what I'm talking about, man. So Shaw also settled in Pittsburgh, and having known Ferris in Memphis, Tennessee, as Wash, the slave of Mr. Ragland, informed the latter where the slave was to be found. Wash, alias Ferris, having gone to Missouri in search of work, Shaw followed him and had him arrested at Brunswick, Missouri, and returned to his master, for which he received a reward of $500. Oh, he got paid for snitching. Offered by Ragland for the return of the slave. Shaw returned to Pittsburgh and was there indicted upon a charge of kidnapping and convicted as stated. It is to be hoped that a more honest jury will be found at the next trial. A more honest jury. Oh my gosh. An amusing report from Memphis shows how difficult it was to distinguish the mulatto. Oh, it's getting difficult to distinguish these mulattoes, man. You know, at Ragland, in the summer of 1838, the monotony of Memphis was relieved by the sudden appearance of Monsieur Duquet, an individual of foreign aspect, peculiarly French in his accent and the color of his cuticle. He came in pursuit of health, and to escape the heat and malaria of more southern climate. Agreeable in conversation and prepossessing in manner, he was not long in making himself the center of social circle. The ladies smiled delightedly in his presence, and through the long summer months no party or fashionable assemblage was complete without Monsieur Duquet. He sang charmingly in French, but his greatest attraction was the possession of two sugar plantations. All right, that's his most highest value right there. He had two sugar plantations, huh? He claimed an annual, sorry, I got two sugar plantations in Louisiana, or the upper plantation. He claimed an annual production of 400 hogsheads and 600 on the lower plantation. This was enough to sweeten his society and give a saccharine tinge to his general conversation, all right? We're talking about possible black slave owner, right? Most likely might be Huguenot. Who do K? We gotta look into the genealogy, or Indians mixed with Huguenot, whatever. Acadian, Cajun, you know, could be many things. Now, he sang charmingly in French. Okay, we got all that. He got two plantations. He's making mad money. He's getting accepted into society, right? The merchants too were happy to make his acquaintance. Who's the merchants, man? Remember who the merchants are, man. Of course, they're gonna make business with him, man. He got a plantation. Two were happy to make his acquaintance. He talked eloquently of finance, but all things have an end, and it become necessary in the course of events for Monsieur Duquet to depart. And on the event of this interesting occasion, he deplored with tearful eyes the necessity that compelled him to return to his plantations. He was consoled, however, with the reflection that he would shortly return. From a friend in the grocery line, he purchased a bill of supplies for the upper plantation, giving in payment a draft on his New Orleans merchant. From a dear old friend, he obtained in similar manner a fine riding horse, saddle, and bridle, and from a bosom friend and companion, he reluctantly consented to receive a diamond ring for his only sister, months passed away, and no tidings came to the elegant Frenchman. The drafts were duly returned for non-acceptance, but during the ensuing winter, a gentleman with whom he had been intimate happened in New Orleans and found Monsieur Duquet manipulating in the capacity of a quadroon barber. Uh-oh. They found, so now he was black again. Now he's black. Now he's a barber. He's black now. Oh man, that's crazy. Hey guys, so I hope you're enjoying the reading. We got 6 more pages to read and then we're done. All right, we're close. We're close. All right, we're almost there. The following shows again how difficult it was for slavers to distinguish persons of Negro ancestry. This is a case in which owners sought to recover damages from a white man for enticing from his service a mulatto Negro woman. In this instance, it appeared that the slave girl, Harriet, was the daughter of a woman by the name of Rose, who was possessed and claimed by Denan, who resides in Georgia. About 2 years before the occurrence which forms the subject of this suit took place, the girl Harriet made her appearance in Sevier County, Tennessee, passing by the name of Irene Sanders, and assuming to be free. And as she was white, no one suspected that she was a slave, right? Because she was declared white, right? Or that she had any Negro blood. The girl Harriet was residing with the defendant when the plaintiff went to his house and claimed her as his slave. The girl admitted she was a slave and was taken by the plaintiff into his possession, and they set out for Georgia. Some of the neighbors of the defendant came to him and wanted to know if there was no way of making the plaintiff prove that the girl was a slave. He suggested and replied that as she admitted she was a slave, perhaps they had better let the matter rest. Afterwards, at their request, he drew up a blank process and gave it to them, and they arrested the plaintiff and brought him and the girl before 2 judges, who discharged the girl and committed the plaintiff to prison. After this, the defendant was asked what was to be done with the girl, to which he replied he supposed she might go where she pleased, which declaration was communicated to her. In a few days, the girl left the community in company with a young man by whom she was taken to Rhea County. Evidence was introduced by the defendant that Rose, the mother of Harriet, was reputed to have been free, that she came from Pennsylvania and had been improperly reduced to bondage. That she got disfranchised, right? It was also shown that the girl was of fair complexion. Guys, man, this is a lot of drops. This is a lot of examples and cases. This is good. All right. With straight hair, I think knows, with all other indications of European descent, supposedly, right, and that she lived 2 years in the neighborhood without any person having the least suspicion that she had any African blood, right, or Negro, or was a slave, right? Basically, that she was so called black. Lord Lyle relates an incident that also shows how easily race mixture might be undetected. He declares a recent occurrence in Louisville places in a strong light the unnatural relation in which two races now stand to each other. One of the citizens, a respectable young tradesman, became attached to a young seamstress who had been working in his mother's house and married her, in the full belief that she was free and a white woman, so called white woman. He had lived with her some time when it was discovered that she was a negress. Oh no, she's a negress and a slave. So it's not the same, huh? Yeah. Who had never been legally emancipated, so that the marriage was void. Yet a separation was thought too much a matter of course that I heard the young man's generosity commended because he had purchased her freedom after the discovery and given her the means of setting up a dressmaker. The evidence seems to show that where the mulatto was not known in many cases, the possession of white skin was a presumption in favor of freedom. So if you can pass, you light enough, right? The possession, okay, so we got that. And there is evidence that public opinion sometimes rebelled at the idea of holding white people in slavery. So called white, remember? Niles registered quotes from the Emporium printed at Louisville, Kentucky as follows. A laudable indignation was universally manifested among our citizens and even among the blacks on Saturday last by the exposure of a woman and two children for sale at public auction at the front of our principal tavern. This woman and children were as white as any of our citizens, man. But they were as white as I, man. They're like, hey, he's white as me, man. They're not Negroes, man. And plus, I like them, man. They're like, cool, man. They are neighbors, man. This woman and children were as white as any of the citizens, he said. Indeed, we scarcely ever saw a child with a fairer or clearer complexion than the younger one. That they were not slaves, we do not pretend to say. But there was something so revolting to the feeling at the sight of this woman and children exposed to sale by their young master. It excited such an association of ideas in the minds of everyone. It brought to the recollection so forcibly the morality of slave-holding states that not a person was found to make an offer for them. The legal maximum of part sec vent has made them slaves for life, and the same maxim will make the offspring of these children slaves. Who can think of this and not shudder? Can there not be some limitation, some bounds fixed to the principle? We trust we shall not see a second attempt to sell them in this town. So the guy is literally trying to fight for them. He's literally saying, "Come on, man, how can we stand for this? You know, she's almost as white as us. You know, she's white in status. Like, let her forget about her black ancestry. All right, how could anybody let this happen?" That's what he's complaining about, right? A similar case is reported from Salt River Journal, a paper published at Bowling Green, Missouri. The record is as follows. A case of a slave suing for his freedom was tried a few days since in Lincoln County, of which the following is a brief statement of particulars. A youth about 10 years of age sued. 10 years of age, listen guys, a 10-year-old is suing for his freedom on the ground that he was a free white person. Man, whoa, hold up, man. Apart from all the hijack and all this thing that's going on, that he's going to court and he has to fight for his freedom. Apart from all that, man, he's 10 years old and he knows about status and I got to be white, man. Like I got to fight for my freedom, man. Like that's amazing to me, man. That's amazing. That's just to me. That's just amazing alone. Like just that part right there. I'm gonna find out who that is. Like this is crazy. I'm gonna find that out. I'm gonna find who that is. That sounds like a crazy story. Upon his trial before the jury, he was examined by the jury and by two learned physicians, all of whom concurred in the opinion that very little, if any trace of Negro blood could be discovered by any of the external appearances. They're going off appearance. They're just going off appearance. This is crazy. They admitting, guys, in court. They're going off appearance. This is legal stuff they're doing. Legal fiction. Legal fiction here. His skin was white and fair, his hair soft, straight, fine and white, his eyes blue, but rather disposed to the hazelnut color. Nose prominent, the lips small, completely covering the teeth, the head round and well formed, forehead high and prominent, the ears large, the tibia of the leg straight, the feet hollow. Notwithstanding these evidences of his claim, he was proven to be the descendant of a mulatto woman. Too bad. They said, too bad, man, your mom's mulatto, man. Damn. And that his progenitors on his mother's side had been all still were slaves. Consequently, he was found to be a slave. And in fact, they were like, in fact, your people are all slaves, so now you a slave. Thanks for letting us know. That's messed up. You see how they playing with people? This is what they doing back then, guys. This is real history, real stories. This really happened in history. This really happened to people. This really happened to your ancestors, a lot of them. Now he got disfranchised totally. He was like, man, I'm white, man. I'm white, man. Look how white I am, man. Look at my blue eyes, man. The first Irish had blue eyes, and they were dark skinned. What's up with Cheddar, man? Just from the feeling manifest by the community where the trials was held, we presume his freedom will be bought and his education provided for. Damn, we assume. The editor of Now Register declares the case stated above is called a hard one. It is among the abominations that attend upon slavery, in which in some cases we fear that fathers have made a traffic in their own children as slaves. We well remember a conversation with Mr. Calhoun when Secretary of War in which he introduced this subject. He stated a case in which the feelings of a large assemblage had been much outraged by the exposure of a man placed upon the stand for sale, whose appearance, he said, in all respects gave him a better claim to the character of a white man than most persons so acknowledged could show. And he thereupon suggested that some regulation ought to be made by which individuals so circumstanced, all right, should be declared to be free men. Should be declared to be free men. They was like, but wait, man, who's this guy being sold? They're like, man, he look like a white man. Like, what's going on here? Huh. Conditions and sentiment, as indicated above, helped to make the way easy for the mulatto who did not wish to remain in servitude or to live under the jurisdictions placed upon free Negroes to move and seek his fortune as a white man. Pay attention. In 1834, a free Negro fell into the hands of the law in Virginia. His is the story of a man so white, so white, and hence so likely to make his escape that men would not risk enslaving him. The record of this case recites that a mulatto called William Hayden was apprehended in the county of Prince William and committed to the jail of the said county, and advertised as the law in such cases directs, and was by order of the county court advertised for sale. And no person having claimed him, and he not having proved his freedom, he was offered at public auction for sale. When one Robert Limpscomb, being a bidder, and making the highest bid, became the purchaser of the said Hayden, as agent of a trader or dealer in slaves, he Lipscomb informed your petitioner that his principal would pay the purchase money in a few days. The said Hayden was returned to the jail to await the arrival of the trader, who in short time came and being requested refused to pay the amount which he had authorized the said Lipscomb to bid. Your petitioner afterwards sent the said Hayden to the town of Fredericksburg and the city of Richmond by one Colonel James Farrell of Prince William, who had a number of slaves to be offered for sale, to be sold if the amount could be obtained for him equal to the said Lipscomb's bid. The said Hayden was offered for sale to sundry persons in Fredericksburg by Farrell and myself. He was also offered in Richmond by Farrell, all of who refused to purchase him at any price on account of his color, all alleging that he was too white. That said Farrell returned him to your petitioner in the town of Brentsville when he offered him for sale on a court day. Several traders were present, all of whom refused to make any bid for him, all alleging that his color was too light, and that he could, by reason thereof, too easily escape from slavery and pass as a white man. And while your petitioner was endeavoring to sell the said Hayden, he made his escape. And although your petitioner has made every exertion to regain possession of him, he has not been able. Wow, that's what's up. He got away. While they're trying to decide it over there, the Hydra is selling him and not treating him like property, he escaped. He ran away. That's what's up, man. But this is crazy. Just because he's so light, he got away with not even like people didn't even want him as a slave. That's crazy. You understand? Overstand that part? They're like, nah, he's gonna escape. He's gonna pass for white, man. Economic and legal restrictions on free Negroes, enslaved and free states would seem to and did operate to force many mulattoes of light complexion to desert their mulatto fellows and become white men. Okay, but this by no means was always the case. It wasn't always the case, but it happened. A lot of your white folks today are still literally passing for white. Like they kept mixing with other. They they didn't tell nobody. They're not telling nobody about their so-called black ancestors, right? Or Indian, or whatever you want to say, right? Black Europeans, whatever they want to say. Light mulattoes did not universally attempt to gain recognition of white men. William Hayden, mentioned above, affords an example of this kind. He was seized and sold as a slave because he had in Ohio and later in Virginia refused to associate with the white race and let it be known to his associates that he was of Negro blood. So listen, that's deep right there, because even though he's that light skinned, he's that white looking, he was always with his people, so-called black folks. He'd rather be with black folks, with his people, because he was of Negro blood. Of Hayden, it is said that he was born free in the state of New York, was the son of a white woman, and was educated in that state, which was evident from his pronunciation. At the age of 14, he went to the state of Ohio, where he continued about 3 years, when the increase of that population with which he associated became so numerous as to induce the constituted authorities of that state to enact severe laws in relation to the policy of the state, which compelled all persons of his color, which were not able to comply with the requisitions of the laws, to seek asylum elsewhere, and that he was endeavoring to return to New York, the place of his nativity, and not having been acquainted with the Virginia laws, attempted to pass through the said state without the evidence of his freedom. Your petitioners have a strong belief, and so have others, that he, the said Hayden, was born free. His knowledge of the state of New York, his acquaintance with geography of New York, his acquaintance with the cities, towns, rivers, and the trade of the state is calculated to convince any person that he was born, raised, and educated and migrated as he, the said Hayden, represented to your petitioner. In the slave period, the governing classes did not desire to admit persons of Negro or Indian blood to the ranks of white society. The laws described in this chapter were designed to preserve the racial purity of the white man's blood. That's deep right there, guys. This is paper genocide. That's ethnic cleansing. These laws serve the okay, so we got these laws failed to accomplish their object, and in unknown numbers of cases, the blood of the proscribed races found its way into the veins of many white families. So a lot of you white folks today, guys, come from black folks. This is what I've been trying to tell you. So-called black, right? Crayon colors, right? You know, the complexity of genealogy. So before the end of the slave period, there were no doubt many persons who could truthfully testify, as did so-called white wife of a white citizen of Virginia, that she did not know whether she was entirely white or not. Like, I don't really know, man. I just know she knew. She knew who her people were. You just didn't want to say. I know I'm mixed. I just, I don't know. I don't know if I'm black. I don't know I'm white. It is impossible to conceive a legal system under which such an infusion, of the dark man's blood, the dark man. The dark, that's not a country, tribe, or nation. That mean. What do you mean, dark man? Who? Could be a black European, could be American Indian, could be many things. What are you talking about, man? Dark man blood. Would have been impossible had the state laws provided that any Indian or Negro blood made the individual possessing such blood a person of color. Anybody that had Indian or Negro blood, you became person of color, because it's the same thing. They're admitting That is the same thing right there. There would have been more delicate problems presented to the courts. In the language of Chancellor Harper, such a law would have proved a very cruel and mischievous law. And under the more drastic law, natural forces would still have defeated the purpose of the lawmakers. But there were forces which served more effectively than all laws and did more than any law to obtain what the lawmakers desired. Had the existing laws been rigidly enforced and every individual, slave or free, or less than 1/4 degree of Negro blood, been forced to accept the status of white citizens. It is difficult to conceive of the resultant state of Southern society. According to such an interpretation of the law, hundreds of individuals who lived all their days as Negro slaves would then have been forced to accept the status of white citizens, forced to accept from Negro slaves to white citizens. Pay attention. My hair stand up because I'm like, I've been trying to show this whole time. Like, thank you for like saying what I've been trying to say, tell people. So stop judging. It's complex. People's genealogy, even white folks, is complex, guys. But again, forced to based on the benefits, and because if you don't, you're disfranchised and then you're oppressed and all this other stuff. So you're forced to become white citizens. But all the mulattoes did not wish to become white men. That's what I was saying earlier. That was their choice, though. You're either a Negro or you become white, man. Come on, man. And like, but I don't want to be white, man. I know who I am, man. We Indian, I got some Highlander blood, I got some German, but I got, Chickasaw, I got some Pakana. Man, yeah. I got some Catawba, I got some, Algonquin blood, Shinnecock. I don't want to be white, man. So these mulattoes, some of them, they didn't want to be white, man. And the vast majority of the white Negroes, all right, I want you guys to see that. I'm going to highlight it. They got it in parentheses. It's a real thing, white Negroes. In history, it's a real thing when it comes to statute laws and the history of reclassification, white Negroes. So these white Negroes made no effort to desert the mulatto group. A change of status might offer freedom, opportunity, and the end of persecution. But such persons were bound by the strong ties of friendship, relationship, affection, and family tradition to the despised and persecuted group. And in most cases, they remained with those who loved them and they suffered with them. That's some real right there. That's real. You kept it real. You ain't trying to pass for white. Because a lot of people who passed for white, they weren't evil. They weren't doing it because they want to leave their people. They just, some of them didn't even have families. But there's some real people that had the option to become so-called white or be labeled mulattoes or black, and that disfranchised them. That gave them, took away all their benefits. And that's real right there. A lot of people will sell out today. A lot of so-called black folks would do the opposite, sell out. Money may weather, money may weather, money may weather. Yeah. I ain't making this up. You know what I'm talking about, man. You gotta talk real shit. You gotta be real, man, sometimes, guys. Stop beating around the bush and trying to be politically correct and not upset the followers and my subscribers. Nah, man. We're reading real history right here. And there's some real people in this history that decided to stay with their loved ones, the persecuted people. Nah, that's my people, man. What you talking about? Whatever you do to them, you do to me, man. That's my people, man. Don't worry about what you want to call me, man. I don't care if you allow me to vote or carry a gun. Don't worry, I'll find a way to get a gun. I'll find a way to vote. I'll get you out so we can vote eventually. Don't worry about that. We'll get that fixed. So they stay with their people, man. They remain with those who love them and they suffered with them, man. They suffered with them. In this problem of racial identity, social forces prove stronger than economic inducements and far more effective in preserving racial integrity than legal acts, okay? Preserving racial integrity than legal acts. Body bag. The whole chapter was a body bag, drop after drop, man. Get some real history, man. Get some real context, man. Right? Hold on, we ain't done. Hold on, we ain't done, man. Where'd it go? I want to go back to, where is it? Hold on, guys. Gotta go back to the ChatGPT real quick because before for the dismounts, real quick, I wanted you guys to see the summary. We're gonna summarize the chapter a little bit, right? We're gonna summarize the chapter. Hold on, let me see. Okay, here we go. So I posted the whole chapter to ChatGPT, right? As you guys can see, I pasted the whole chapter. So what does it say for the dismount, right? For the summary, for the breakdown, right? This chapter is one of the clearest examples of why racial labels in Southern records must be treated as legal and social constructions rather than simple biological facts. The author is documenting, not always perfectly interpreting, all right? Not always perfectly, the hijacks are in there, that race in Virginia and the South was often determined through law, reputation, status, and jury opinion rather than clear ancestry, okay? Chapter 8, Academic Breakdown. The central argument of the chapter, the author's main point is that by the late colonial and antebellum South, racial mixture had become so extensive that many people, right, so-called mixture, right, many people legally classified as Negroes, mulattoes, or persons of color were physically indistinguishable from those classified as white. This is extremely important. He is not saying race was scientifically clear. He is saying the opposite. The system was unstable, inconsistent, and often impossible to enforce. This directly supports the idea that Negro did not automatically mean African ancestry in a clear modern sense, body bag. And white did not automatically mean pure European ancestry. Legal race was often status category. Many people cross categories on paper and in life. They got switched up every 10 years, right? This is exactly the issue of reclassification and what we would call paper genocide. Important primary evidence versus later interpretation. This is the problem we have today. Later interpretation, modern people, modern us, historians, us, our master teachers, everybody interpreting the primary source is wrong. You don't have no context. Original records and court cases from the author's own racial interpretation, right? From A to B, right? So you got original records and court cases that we read, and then you got the author's own racial interpretation, right? When he's saying Nordic and African, when he's adding his hijack, right? This chapter contains both. The court records are valuable. The author's references to Negro blood or Nordic blood, you see? Species, calling people species, and race science reflect early 20th century racial assumptions and must be treated critically, all right? So the ChatGPT caught the hijack. Literally, the ChatGPT caught the hijack in the whole chapter, right? So it's telling me we gotta be careful when they're saying Negro blood, Nordic species, all that. Those are interpretations, not primary evidence, right? Mulatto was a legal category, not a stable biological fact. This is perhaps the most important section, right? Virginia 1785, every person who has 1/4 or more Negro blood shall be deemed a mulatto. So it don't matter if you mix or not, you're gonna be deemed a mulatto if you consider Negro. This is not biology, this is law. That means someone could be legally white, pay attention, somebody could be legally white, socially white, visually white, but still have known ancestry outside of white, or someone could be visually white, but legally classified as mulatto because of genealogy. This proves race was administrative, okay? Race was administrative, all right? Legal fiction. Race was administrative. It wasn't based on ethnicity, or genealogy. Not purely physical either, not complexion, not purely ancestral, not purely visible. 4, Negro included mulatto. Very important, right? Virginia law states that the word Negro shall be construed to mean mulatto as well as Negro. The same thing. Had nothing to do with people mixing many times. This means when later historians, right, read records saying Negro, they often wrongly assume African full ancestry. You see, they assume. Modern historians, they try to say African, all these Pan-Africans, everybody, these black scholars, these black professors in the university, they assume. But they see the word Negro or mulatto. But legally, Negro could include, listen, quadroon, octoroon, mixed Indian ancestry, socially reclassified people. Negro can mean status, basically. Socially reclassified people, or people that lost their status, their sovereignty, that got disfranchised, detribalized. This supports your major point exactly. Exactly, yeah. The record itself does not prove African origin, but that's it. Bottom line right there. Point number 5, court literally determined race by looking at people. All right, we saw that throughout the chapter, right? All those cases they were showing us. That was crazy. The court literally determined race by looking at people. This is right. This is one of the strongest sections. Juries, listen, juries inspected bodies and decided white, mulatto, Indian, or Negro. That was people. Juries were deciding this. And they weren't using genealogy or spitting in the tube like today. Based on hair texture, right? This is what they were using. Hair texture, nose shape, eye color, skin tone, reputation, family memory, community acceptance. So if that community, let him be white. Nah, he's a black. Make him a black. This is not science, guys. It is social judgment. Sometimes absurd judgment. Yes, crazy. This shows racial identity was negotiated, not fixed. Racial identity was negotiated, not fixed. Racial identity was negotiated, not fixed. Pay attention. Get rid of all your stereotypes too and all your prejudices too. Don't be like these people. This should make you a wise person. This should empower you. This should make you more conscious of others. This should make you a better person, actually. Number 6, points, Indian versus Negro classification. Extremely important. Many cases show people argued, I am Indian, not Negro. Many cases, right? Many cases of people saying, I am Indian, not Negro. This mattered because Indian ancestry could preserve rights denied to Negroes. Okay, this mattered. That's why. They didn't want to be disfranchised. Example, North Carolina case, man of olive color, long hair, prominent nose. Court ruled he may descend from Indians rather than Negroes. And granted freedom. And it don't matter if the Indian he descends from were actually Negroes. They don't matter because in status they were called Indians. So he was granted his freedom because of that. This directly proves that dark complexion does not equal African, okay? That's what it's saying, does not equal, right? Dark complexion does not equal African. Courts themselves recognize that. Courts themselves recognize that. Why don't you recognize that? Modern historians often ignore this. Your master teachers often ignore this. Part 7, reputation could override blood. Your reputation could override who you come from. South Carolina case is crucial. Justice Harper says, a person may be legally white based on public reputation. You may be white if the people accept you, right? If your reputation is good, you got good wealth, you got good business, you got good standing. Social acceptance. You can be white if you got social acceptance. You got militia service. You can be white. If you actually vote, then you can be white. Marriage into white. Oh, you can be white now. Even with known African ancestry, so-called black, right? Hey, man, ChatGPT, why you doing that, man? You know not to bring up that word, man. you meant Negro or black, so-called black or Negro ancestry, right? Or coming from people of color, right? So he explicitly says if any remote Negro ancestry automatically made one colored, that would be cruel and mischievous. That would be cruel and mischievous. This is devastating to modern one drop rule assumptions. The one drop rule was not the original standard. That came later. Earlier law was much more flexible. Part 8, wealth and status change race. Wealth and status change race. Joseph Newman's case is especially revealing. He was wealthy, treated as a white man, descendant of Spanish settlers, most likely Swarthy, also had Indian and Negro ancestry. Like I said, they were Swarthy. They're trying to say that Negro, what Negro, because he's black, they're trying to add some African into him. Remember, but we saw his case. Only after inheritance disputes that his enemies discovered Negro ancestry. They used that against him. Now he wasn't a white man anymore, right? Because they wanted his property and his wealth, right? This proves race could be weaponized politically. That's a major one right there. Thank you, ChatGPT, for recognizing that logic. That proves that race could be weaponized politically, and it was weaponized politically. You are prisoners of war. You have been paper genocided. They did take your land, your status, your identity, and look what they got. Look what they're doing now. Race was not just biology, okay? It was property law. Power, inheritance, and control. Man, this is deep, guys. This is a big lesson today. I hope you guys share this everywhere, okay? Make them watch it. Say, no, you got to really watch it. If not, don't talk to me. I want to hear, this is real stuff. Listen to it from the end, to beginning to end. Debunk one thing. Pay attention and gain some wisdom. Forget about what he looks like or who's reading it. It's about the information he's informing you with. The real history to help you be a better person. Now be quiet and sit down and watch this. Part 9, passing was common. Passing for white was common. This chapter openly states many people passed as white. Examples: slaves mistaken for white men. White communities are unknowingly accepting slaves. Marriages formed before discovery. People legally reclassified as white by courts. People that were actually black, right? People very dark complexion, but they got classified as white in court. They beat the case. This is not rare. Okay, guys, this happened a lot. There was many cases like this. This is not rare. The author repeatedly says it was widespread. This matters greatly for genealogy. Exactly. That's why it's important. That's what I'm trying to tell you. You find white, you find ancestor being called white. Don't think white automatic. Don't think, oh, that's my European. Oh, that's a slave. Oh, that's not my people. Nah, be careful. You got to understand the context. Don't just go off to what the record is showing you. Paper categories cannot be treated as absolute truth. Body bag. Thank you. Thanks. I didn't know he's about to say that, the ChatGPT. This matters greatly for genealogy because you can't just go off what the paper's saying. You got to have context, what these words mean. In law, it says 10, white was also flexible. This chapter proves your earlier point. Why? What I told him before I even showed him the chapter. So he didn't know what I was about to show him. ChatGPT didn't know. I bet you ChatGPT does not have this chapter coded in its programming until now and it's not going to stay unless I click on this conversation for this day, and that's it. That's the only time it'll remember. So anyways, white was also flexible. This chapter proves your earlier point. White was often determined by recognition by community, political participation, militia service, marriage patterns, economic respectability, not just complexion. Justice Harper even says a respectable man may be white while a vagabond of same ancestry may be colored. Of the same ancestry, like I said, it could be his brother. It could be his brother. His brother's a drunk, he black. His brother's wealthy, rich, high status in society, he's white. That's crazy. I'm trying to make you understand this, guys. This really happened. They were really doing this to people, right? So that is status. Again, that is status, not biology. Extremely important. And it says here, part 11, Spanish Gulf Coast cases. Alabama, Florida, Mobile examples are major. Mad cases in these areas. Pay attention. If you're from these areas, these involve mixtures of Spanish, French, English, Indian, Mexican, and Negro. And again, all these could be swarthy people. So you would never know that you're all this if you think you're just one thing. Just because, oh, my color says I'm Indian. Forget about my Spanish, forget about my French, forget about my English, forget about my Mexican. They don't mean Mexican how you think Mexican. They mean just mean coming from Mexico. And Negro was Negro. Anybody that could be black. That could be an Indian. That could be, again, discern through the info, guys, right? So these involve mixtures of all these people, right? The courts themselves struggled, and because of that, it was hard to pinpoint what people were, right? So they tried their hijack ways, and that's what created the paper genocide. And again, they did it on purpose, not just by mistake, right? The courts themselves struggled. This destroys simplistic black-white colonial narratives, especially in Gulf Coast history. Part 12, where the author overreaches. I like this part, right? We must reject several parts, especially species of human race. When he says species of human race, that's that hijack Darwinism, white superiority, white racist views, right? Skull measurement claims, that's the hijack. Craniology is based off them trying to prove that black folks skulls is different and inferior. That was the basis of craniology, the study of craniology, guys. So it says Agassiz, Morton, race science. Yeah, all that is white superiority stuff. Nordic blood purity discussions. Again, all these must be rejected. Listen to what ChatGPT is telling you. All the hijack. I told you. I told you. These are products of early racial pseudoscience, which became our modern interpretations, actually. This was pseudoscience coming out in the late 1800s, early 1900s, useful as evidence of how people thought, but not proof of ancestry. Exactly. So when I say I'm reading this to you guys, so you guys can see the hijack, how deep it went, not so we can believe what they're saying. Oh, hey, he got African blood because he's dark skinned. No, I'm showing you how this guy is interpreting falsely this person's ancestry. So you can know this happened. It might have happened to your family, so you can be aware of that. We separate those from actual legal records. Separate all that hijack from the actual records. Yo, this is a good breakdown, right? So what this chapter strongly supports, right? Part 13, it strongly supports that one, race was often legal fiction. Race was legal fiction. Again, race was legal fiction. Legal fiction. They made it all up and they called it law. Number two, Negro did not automatically prove African ancestry. Okay? Body bag right there. Bottom line. I mean, we've gone over this for years, right? Number three, white did not automatically prove European ancestry. Keep that in mind. Two, four, Indian ancestry was frequently involved. There's mad Indian blood in you. Reclassification happened regularly. This was a major thing. Paper genocide was massive. That's why you don't know who you were for years. That's why you were led to believe and allowed to be reclassified. Your own people allowed it to happen. It happened regularly. Paper genocide happened. Passing for white happened on a large scale. Passing for white happened on a large scale. 0.6, right? 0.7, court could change race on paper. The court can automatically make somebody black or white, no matter about complexion. Reputation often mattered more than ancestry. Your reputation, your wealth, your status mattered more than your ancestry. That one right there is crazy. But it was real, guys. It really happened. Number 9, slave records are not simple ethnic proof. Exactly. So when you're looking at these slave schedules, guys, you find slave schedules in your genealogy and all that, you have to have context because it's not simple ethnic proof, meaning these are Africans or Negroes. Oh, they're not Indians because they're being labeled black or Negroes or not even labeled anything. They're just a number, right, on these slave schedules, right? Or they're just being called Negroes, right? That doesn't prove anything, these slave records. That's what I'm trying to explain to you guys for a long time. Modern historians often oversimplify colonial labels, and then we got the hijacks of today. Yeah, I'm gonna call them the hijacks because they purposely, a lot of them, just there's no excuse anymore, guys. We're in 2026, people want to still talk about all this other African stuff, or that all Europeans are white, or that all the hijacks we learned growing up. If they're still stuck on that, then these modern historians, they're not just oversimplifying colonial labels. They're doing that on purpose. They ain't trying to learn, man. They have a long learning curve, I guess. Very long learning curve. But they're the professors, right? They got more degrees than me. So point number 14, most of important line in the entire chapter. What is the most important line? Probably this one. He says, the vast majority of the white Negroes made no effort to desert the mulatto group. All right. Why did that's deep that he chose the ending of the chapter. Like he thought, I thought that was deep. When I remember I stopped at that part, I said, "Oh, that's some real shit." These people decided to stay with their people, no matter how they were gonna be disfranchised. And the ChatGPT thought so too. He said this is one of the most important lines, that the white Negroes made no effort to desert their mulatto group. This tells us many people who could legally pass as white did not. Why? Because identity is social, familial, and communal, not merely legal. Apart from all your hijack, these my people, man. I ain't leaving my people, man. That is a profound historical point, man. I'm glad you think so, ChatGPT. I thought so as well. That is a profound historical point. Shout out to the real ones in all history. Final scholarly conclusion. This chapter does not prove modern racial categories. It proves their instability. It shows that colonial and southern racial identity was often a bureaucratic and social negotiation, not a clean biological classification. That is why historians must never read Negro as automatic proof of African origin. Historians must never read Negro to mean African origin. But what happens? That's all they do today. That's all they do today. That's all historians keep doing today and have been doing for so long. That's all they do. Let them know, ChatGPT, based on the sources that ChatGPT got informed with. I pasted the whole chapter here. So it's being logical with real reasoning. This is how people are supposed to reason. But people are missing context, right? Because they choose to be ignorant. They don't want to believe what we're showing them. So they'd rather not watch the video. They'd rather not learn. They'd rather ignore the real research of primary sources. Again, that is why historians must never read Negro as automatic proof of African origin, and must never read white as well. All right. Well, you people will be hating on the word white, like you have hate for the word white and what you think it means, right? And you must never read white as automatic proof of pure European ancestry. The chapter actually undermines both assumptions. Exactly. It undermines both assumptions. Where's my thumbnail, man? What happened? All right, hold on. Yeah, guys. Well, we reached the end, man. I mean, that was a lot of drop. I really enjoyed reading this chapter, you know. Actually, I did. And I'm glad I did it live just to add my emotion to it, and we can learn, we can read it together live, because I hadn't read the whole chapter completely by myself, you know. So it's a good thing that we did it together. We're learning. We have a lot of years of research behind us. We have a lot of context. All right. Let me just let me just say what's up to everybody. I appreciate you guys that tuned in. You know, thank you for coming through. Appreciate it. I hope you guys enjoyed it. I hope you guys help me share this information, and I don't know, somehow figure a way to get people to sit through it. I know it's a long video, 2.5 hours almost. I know a lot of people are just refused to hear this out because of what I look like or whatever. I mean, I'm showing myself today on purpose, guys. You know, I want people to judge. You know, go ahead and judge me. Go ahead, judge me like the jury in the court cases. What am I? Anyways, um, Appreciate you guys. We're gonna go out with a banger. Hey, Rob, what should I go out with, Rob? What song, Rob? You said one earlier. Which one was that again? Let me get that. I know you're here. Let me get that going. Shout out to the Dracons. Eh, let me see, Rob. Which one you talking about, Rob? Yeah. Yeah. Shout out to you guys. Shout out to all my channel members and all my patron supporters. I'm uploading like some like nice little shorts for my members and patrons, you know. You know, it's exclusive stuff, you know. So check them out if you're not there yet. All right, hold up. Let me see. Hey, Rob, you still there? All right, don't worry, man. Let me see. I know you got this stuff is too confusing. It's not confusing, man. Take your time with the info, man. Discern it, you know, absorb it. How do you say that? Digest it, digest it. You know, we've been here 9 years, you know. It is confusing, but what's confusing is the confusion that we got indoctrinated with. That's why you're confused, because we indoctrinated. You got to break out of that. Once you break out of the hijack, empty your cup, you got to see how clear it is. It's not confusing at all, man. It's not confusing to know yourself, my brother and sisters. It's not confusing to know yourself at all, man. It's not confusing at all. It just becomes a little hard with the hijacks. Yo, Rob, man. Hey, Texas, what song should I go out with, man? Oh, he probably left. He probably left. It's all good. Let me see. I don't want to. I'm gonna just put the theme. Forget it. Let me see. I got here. What we got here? Oh man. Yeah, appreciate you guys. Thank you for tuning in. You know, we're at the end. If you came late, make sure to check out from the beginning, man. It was a good video. Check it out from the beginning. I gotta find the theme. I'm finding the theme, man. This is from Robin Dre Beats, man. It's from Robin Dre Beats, man. Let me see. Dang, I don't have it. Where is it? Where is it? It's all good. It's all good. We in tune. We're gonna go in tune. Now that we in tune. Appreciate you guys coming through once again. I'm gonna go ahead and share the screen. Thank you. Pura vida, mi gente. Hold on. Uh-huh. 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 I got mad windows open. Uh-huh. 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 Yeah, here we go. There we go. Yeah, yeah. Pura vida, mi gente, man. Much love and respect. I hope you enjoyed it. Make sure to share, subscribe, like. Come on, help me get this info out. Get to know me if you don't. All right. Stop judging people by appearance. I hope you're learning. Like, stop judging people by appearance only. All right. If not, you're doing the same thing these courts were doing to your own folks. You're doing the exact same thing if you're judging people only by appearance. All right. Much love and respect. Pura vida, mi gente. Wow.
Robert Dre, Bye.